from disclosure risks to shared responsibility in a transaction. In the previous section, we explored how failing to disclose, even something unusual, can create serious legal consequences. Now we take that concept further by addressing a critical truth in real estate. Disclosure is not a one-way street. While much of the focus in real estate law is placed on the seller's obligations, buyers also have responsibilities that directly impact the success of a transaction. Understanding both sides of this relationship is essential to avoiding disputes and ensuring smooth closings. A home buyer's responsibility to disclose a buyer must act in good faith and deal fairly with the seller. This means a buyer cannot present themselves as ready, willing, and able to purchase a property if they know there is a significant risk they cannot perform. When using standard Arizona contracts, buyers are making contractual representations about their ability to complete the transaction. If a buyer knows of factors that could prevent closing, such as financing issues or the need to sell another property, those facts must be disclosed. Failure to disclose this type of information can create legal issues and may be considered a breach of the buyer's duty to act fairly in the transaction. Financing and performance transparency. When financing is involved, buyers should obtain a conditional loan approval and understand the requirements tied to their loan. This is not just a best practice, it is part of ensuring that the buyer is being truthful about their ability to close. If there are conditions, delays, or dependencies that could impact the transaction, those realities must be communicated clearly to the seller. The goal is transparency, not perfection. Sellers do not expect buyers to be risk-free, but they do expect honesty. A buyer's duty to inspect and investigate beyond disclosure. Buyers have a responsibility to inspect and investigate the property they intend to purchase. Arizona contracts provide a defined inspection period during which buyers can conduct inspections, review documents, and evaluate whether the property meets their needs. During this time, buyers must act diligently. If there are concerns, they must be communicated in writing, along with a clear decision, either to cancel or request repairs. This process is not just procedural, it is the buyer's opportunity to fully understand what they are purchasing. What buyers must investigate. A buyer's investigation should go beyond the physical condition of the home. Buyers should review title reports, CC&Rs, zoning regulations, and any governmental restrictions that could impact use of the property. They should also consult professionals such as inspectors, lenders, and insurance agents to gain a complete understanding of the property. The key principle is simple. Buyers cannot rely solely on the seller's knowledge. They must conduct their own due diligence. Transitioning back to seller disclosure. While buyers have responsibilities, the seller's duty to disclose remains one of the most important legal obligations in a transaction. This duty originates from both common law and statutory requirements and has been reinforced through Arizona case law over time. The seller's common law duty to disclose Arizona law requires sellers to disclose material facts that affect the value of the property and are not readily observable or known to the buyer. This principle was clearly established in Hill v. Jones, one of the most important disclosure cases in Arizona real estate. The lesson from Hill v. Jones. In this case, sellers failed to disclose a prior termite problem that was not visible during inspection. After closing, the buyers discovered the issue and filed a lawsuit. The court held that failing to disclose a known material fact can be treated the same as misrepresentation or fraud. This case fundamentally shaped how disclosure is viewed in Arizona today. As is does not mean no disclosure. Many sellers believe that selling a property as is protects them from liability. However, Arizona courts have made it clear that an as-is clause does not eliminate the duty to disclose known material defects. A seller cannot hide behind contract language to avoid disclosure obligations. When questions trigger disclosure. If a buyer asks a specific question about the property, the seller must answer truthfully. Even if the seller does not believe the information is material, they cannot withhold facts in response to a direct question. Additionally, if circumstances change during the transaction, the seller has a duty to update prior disclosures to avoid creating a misleading impression. The seller's statutory disclosure obligations. In addition to common law, sellers must comply with specific statutory disclosure requirements. These include disclosures related to lead-based paint, homeowners associations, environmental conditions, and property location factors. These laws are designed to ensure buyers receive critical information that may not be visible during a standard inspection. The role of the SPDS. The seller's property disclosure statement, SPDS, is one of the most important tools used in Arizona real estate transactions. It is designed to help sellers disclose known information and reduce the risk of unintentionally leaving something out. The SPDS is not a warranty, it is a statement of the seller's knowledge. Why the SPDS matters. The SPDS helps guide sellers through the disclosure process by prompting them to consider issues they may not have thought about. It also provides documentation that disclosures were made, which can be critical if disputes arise later. While not every question on the SPDS will be material in every transaction, the process of completing it helps ensure a more complete and accurate disclosure. Common misunderstandings about the SPDS. Some sellers worry that completing the SPDS creates additional liability. In reality, the opposite is true. Proper disclosure reduces risk by ensuring buyers are informed. Others believe they can simply write disclosures on a blank sheet of paper. While technically possible, this approach increases the likelihood of missing important information. Bringing it all together. This section connects directly to everything we've covered so far. Advertising taught us how to present information. Copyright taught us what we can use. Fair housing taught us what we cannot say. Disclosure taught us what we must reveal. Now we understand that both parties, buyer and seller, carry responsibility in the transaction. Real estate transactions are not about one side protecting themselves. They are about both sides acting in good faith, communicating clearly, and making informed decisions. The most successful agents are those who guide both buyers and sellers through this process with clarity, professionalism, and a strong understanding of the law. Online discussion. Question: why does a buyer have a responsibility to disclose their ability to perform? Answer: because presenting as a ready and able buyer without the ability to close is misleading and violates the duty to act in good faith. Question: why doesn't an as-is clause protect a seller from disclosure obligations? Answer: because sellers are still required to disclose known material defects regardless of contract language. Question: how does the SPDS help reduce risk in a transaction? Answer: it guides sellers in making complete disclosures and provides documentation that important information was shared with the buyer.